So you'd have a continuing duty of loyalty and confidentiality when it comes to his communications, correct?
Yes.
Now, Ms. Bondi, as Attorney General, one of her first acts, established the Orwellian-sounding weaponization working group. In her memo, it says that the work of this weaponization group will be supported by the Office of the Deputy Attorney General. That is the office that you will occupy. Would you agree that it would be a blatant conflict of interest as his criminal defense lawyer, as someone who has a continuing legal obligation to him as a former client, for you to participate in any of the work of that group as it pertains to the January 6th case that you represented him, or the Mar-a-Lago case where you represent him, or Alvin Bragg's office where you represent him? You would agree that that would be a very blatant conflict of interest?
I don't necessarily agree with that. There will be a conflict of interest potentially, but I quibble with the word blatant. And it depends on,
okay.
I mean,
take out the word blatant, but isn't it a clear conflict of interest? You've represented him in these cases. You acknowledge you still have a continuing obligation to him in these cases. How could you possibly oversee an investigation or review of the prosecutors in these cases when you handled them? How is that not the most obvious conflict of interest?
I am not saying I can or I cannot. I'm saying I'm not going to say to you today, Senator, yes, there's a blatant conflict of interest.
Well, why?
I don't know what the work is.
Well, can't you acknowledge that if you're asked to supervise cases involving your own cases, that would be a conflict of interest?
That's a very different hypothetical. Certainly.
No, it's not hypothetical. You're subject to the order of the Attorney General now to support that working group. That working group is going to look at the January 6th cases and the Mar-a-Lago case, the cases you worked on. So can you acknowledge it would be a conflict for you to oversee that work?
What I'm not acknowledging is the broad strokes you're giving it. That work, for example. There will be conflicts, and I will not violate my ethical obligations.
Well, let me just ask you with great specificity, will you recuse yourself from overseeing the January 6th case, the Mar-a-Lago case, and the Alvin Bragg case? Will you recuse yourself from the working group's supervision of those investigations?
I will follow the rules as told to me by the experts, career prosecutors in the department when it comes to every recusal.
I've heard that.
But it's true.
Well, it may be true in the abstract.
No, it's not abstract. It's true.
Well, here's the thing, Mr. Blanche, which you well know. You may very well get some opinion of an ethics lawyer appointed by the administration to tell you that you can exercise your discretion. If you believe it's a conflict, you can say you won't participate. If you don't, you can participate. So you may have discretion. So I'm asking you, how will you exercise that discretion? Will you recuse yourself from overseeing an investigation into matters where you are his lawyer? That shouldn't be hard.
You just gave a purely hypothetical because the
hypothetical this is not hypothetical. This is in black and white. It says, and I will read it, I hereby establish the weaponization working group, which will be led by the Office of the Attorney General and supported by the Office of the Deputy Attorney General. So this is what you're going to be asked to do. If you are given the discretion of overseeing cases in which you are his lawyer, will you recuse yourself?
It depends. The hypothetical you just described said that a career ethics attorney tells me I do not have to recuse for whatever reason. Because again, we are talking about hypotheticals. If the career Justice Department attorney says to me, you do not have to recuse yourself, I'm not going to sit here today and say that I will still say I will recuse myself.
I mean, that answers my question. You don't think it's a conflict of interest sufficient that you would sitting here today, tell me that you were.
Said.
Yeah, no, I get it. I find it remarkable where we are.
Well, you're restating something I didn't say, Senator.
I find it remarkable that you feel there's any world in which you could somehow participate in an investigation of people where you represented the president in that same investigation.
I didn't say
Well, if you're not willing to commit to recusal, so that means you're willing to entertain supervising that work. So that tells me something. But let me move on because I think you've made your position clear. Let me ask you very specifically about the Mar-a-Lago case. The Justice Department formally had recommended Volume 2 be made public. Do you support Volume 2 of the report being made public?
No.
Okay. Do you commit to preserving the evidence in both those investigations?
I commit for sure to following the law and following the rules.
But you won't commit to preserving the evidence. Let's say you have the discretion about destroying the evidence. Do you commit today to preserving the evidence in both those cases?
I commit to following the law.
Okay. And if you can't commit to preserving the evidence in those cases in which you were the defense lawyer, I think, again, that speaks to the conflict of interest that you have as the president's defense lawyer.
I did not commit to it. I said I would follow the law.
No,
I'm not sure. I'm not sure what.
Mr. Blanche, I understand.
He pointed to criticisms of the department's actions on past indictments and prosecutions, suggesting it echoed defense arguments more than independent oversight. When asked directly if he was still Trump's lawyer, even before full confirmation, Blanche confirmed the attorney-client relationship remained in place for certain ongoing matters. This moment wasn't just a simple back and forth. It opened up bigger questions about how the justice system operates at the highest levels. Reports claim these kinds of ties raise serious issues about impartiality. Schiff didn't hold back, laying out examples where Blanche's past work could create problems. He referenced the January 6th cases and other high-profile prosecutions that had been adjusted following court rulings. The senator wanted clear answers on whether Blanche could separate his previous role from future responsibilities. Blanche responded by acknowledging the relationship, but noted that active criminal defense work had wrapped up in many areas. He explained that while some appeals continued, he wasn't directly involved anymore. Yet Schiff kept pushing, asking about continuing moral and legal obligations, even after any confirmation. Blanche agreed that like any former client situation, there would be duties around loyalty and confidentiality. That admission fueled even more discussion about potential conflicts. Moving deeper into the hearing, attention turned to the weaponization working group established earlier under Pam Bondi. Critics described it as an effort to review past investigations, and Schiff wanted to know if Blanche's involvement would be appropriate given his history. He argued it would be a clear conflict for someone who had represented Trump in related cases like those involving January 6th or documents at Mar-a-Lago. Blanche pushed back, saying while potential issues existed, he would follow ethical rules and guidance from career prosecutors. The senator wasn't satisfied with general answers. He asked for specifics. Would Blanche recuse himself from overseeing reviews of the January 6 matters, the classified documents case, or even the New York prosecution handled by Alvin Bragg? Blanche said he would rely on experts and department protocols rather than making blanket commitments on the spot. This back and forth left many watching wondering about the balance between personal history and public duty. Observers noted how such exchanges reveal the challenges of transitioning from private advocate to top law enforcement official. Another key part focused on the Mar-a-Lago case and related reports. The Justice Department had previously recommended making certain findings public, but Blanche indicated he did not support releasing additional volumes. When asked about preserving evidence in those investigations, he emphasized following the law and established rules. Schiff highlighted this as troubling, suggesting it showed reluctance to commit to basic steps that could ensure transparency. Blanche maintained that every attorney in the department should uphold procedures, but the lack of a direct yes on preservation added to the tension. These details matter because they touch on how the Department of Justice handles sensitive materials and past probes. Rumors suggest ongoing debates about whether previous actions amounted to overreach or legitimate accountability efforts. Supporters of the nomination argue that fresh leadership is needed to address what they see as imbalances from prior years. On the other side, opponents worry that personal connections could influence decisions on everything from document releases to group reviews. Beyond the hearing room, Todd Blanche's path to this role has its own story. After serving as Trump's defense attorney in multiple challenging cases, he stepped into an acting position at the DOJ following changes in leadership. His background includes work on violent crime prosecutions in New York before entering the political spotlight. Fans of the administration praise his experience fighting what they call unfair targeting, while others question if that history makes him the right fit for unbiased leadership. The Epstein file situation added another layer of scrutiny during recent months. As part of transparency efforts mandated by law, the department released large batches of documents. However, concerns arose over redactions and handling that some said protected certain names while exposing others. Survivor groups voiced strong opinions, urging careful review and full accountability. Blanche's role in overseeing aspects of this process drew attention, with reports claiming strategy sessions focused on sensitive implications. He and the department maintained that reviews followed legal standards to protect privacy where required. Critics, including some legal experts, pointed to court actions and sanctions in separate matters involving the administration. One recent ruling referred issues to bar authorities, raising questions about conduct in high-stakes disputes. These elements contribute to the overall picture of a confirmation process filled with hurdles. Republicans on the committee weighed loyalty to the president's agenda against calls for independence, while Democrats used the platform to highlight perceived risks. As the hearing continued, broader themes emerged about the future direction of federal law enforcement. Would the weaponization group expand its scope under new leadership? How might ongoing obligations affect decisions on past cases? Speculation online and in commentary suggested that without clear recusals, doubts would linger. Blanche assured senators he would consult ethics experts and not violate professional standards, framing his approach as careful and rule-bound. Yet the senator pressed on hypothetical scenarios that felt very real given the context. If tasked with supervising reviews tied to his prior representation, what steps would he take? The exchange underscored a fundamental tension in Washington, balancing personal relationships with the demands of impartial public service. Many viewers reacted by noting how rare it is to see such direct confrontation on these ethics questions during confirmations. Looking at reactions across platforms, the clip spread quickly with people debating both sides. Some celebrated it as holding power accountable, while others viewed it as partisan theater designed to obstruct qualified nominees. The truth likely sits somewhere in between, reflecting larger divides in how Americans see the justice system today. Stories like this one keep surfacing because they involve not just individuals, but the institutions meant to serve everyone equally. Additional context from the hearing touched on preserving materials from various investigations. Schiff repeatedly sought commitments on evidence handling, arguing that defense backgrounds could create incentives to limit disclosures. Blanche consistently returned to following the law, avoiding firm yes or no answers on specific cases. This pattern left room for interpretation and further analysis after the session. In the wider political landscape, confirmation outcomes often hinge on committee votes and full Senate consideration. With key Republicans expressing reservations in some reports, the process could involve negotiations or concessions. Observers track whether Blanche will provide more detailed plans on recusals or department reforms to secure support. The stakes are high, as the Attorney General role shapes priorities on everything from national security to domestic prosecutions. Controversies around the weaponization efforts trace back to initiatives aimed at examining previous investigations. Proponents say these reviews help restore fairness after what they describe as politicized actions. Detractors argue they risk becoming tools for retaliation. Blanche's position in this mix, especially with his client history, makes his answers particularly noteworthy. Throughout the testimony, he emphasized commitment to career staff and ethical guidelines. He avoided broad promises that could box him in later, instead stressing case-by-case evaluation. This measured style contrasts with the sharper tone from questioners seeking definitive lines in the sand. The result is a hearing that feels like a preview of bigger battles ahead in the justice arena. Public interest in these topics remains strong because they affect trust in government. When high-level officials face questions about past representations, it prompts everyone to think about potential influences. Rumors continue circulating about internal dynamics and how decisions on file releases or case reviews might unfold. Neutral reports frame the situation as complex, with valid points on both impartiality needs and practical realities of legal careers. As more details from the hearing emerge, analysts break down what it means for upcoming policy. Will there be stronger firewalls for conflict cases? How transparent will future document handling be? These unanswered elements keep the conversation alive and drive engagement from those following Washington closely. The full implications extend beyond one nomination. They touch on long-standing debates about independence in law enforcement and the role of personal history in public positions. Supporters highlight Blanche's prosecutorial experience as an asset for tackling real threats, from organized crime to other priorities. Opponents focus on the appearance of favoritism and call for stricter separations. In wrapping up